So my talk and the paper that accompanies it relate to standards in the world of bioinformatics. So I thought it would be worth spending just a minute on some definitions first, because we've been talking a lot about informatics at this conference, and informatics is a big tent, as we've seen, and I just want to establish what it is I'm talking about. So bioinformatics goes by a number of names. It's also called, to some degree, computational biology, and it essentially means the analysis of large sets of biological data using computational methods. It's a field that was born with the large data sets that were created through the Human Genome Project in the 1990s and many other projects that grew out of that. But the field is characterized by very large data sets, and today anything that ends with omics, genomics, proteomics, metabolomics, and so forth, all feed into this field. That biological science is combined with computer science, and the other characteristic of bioinformatics is complex statistical techniques and computing methodologies that are used to churn through the biological data to develop meaningful biological and human health associations, to discern gene interactions with disease, to help with drug target development and diagnosis, to analyze protein structure and folding, and a variety of different insights that can be gained by looking at this data with sophisticated computational techniques. So that's part one of my talk, and the other part is standards. And so what are standards? What kinds of things do we mean when we say technical standardization? Everything is standardized in the modern world. Everything from the format of your email messages to the composition of the gasoline in the tank of your car, the size of your shoes and your clothing. The list is essentially endless. But we can categorize these standards and talk about which ones I really care about. They're informational standards, right? Informational standards promulgated by groups like the Food and Drug Administration that tell you what is a calorie, what is a unit of cholesterol, what has to be listed on the nutritional facts label of every processed food item that you buy in the grocery store. There are quality standards promulgated by groups like the American Bar Association that say if you're going to practice law in the state of Kentucky or Ohio, you have to meet certain standards. The diamond, the 4 C's, cut, clarity, color, carat, tell you about the quality of the gem that you're looking at. We're all very familiar with health and safety standards that cover everything from electrical wiring and playground equipment and the color of warning signs on the side of the road to environmental protection, again, gasoline content, air emissions, and so forth. And finally, interoperability standards. And this is the category that I will speak mostly about, and the category that is impacted most by intellectual property. And interoperability standards, again, we see these every day. They are the standards that tell you what shape and size electrical plugs have to be so that something you buy at the store will plug into any wall socket in the United States. Railroad gauges, shoe sizes, and more importantly in the computer and networking business, everything that relates to internet equipment, the World Wide Web, HTML, computing standards like USB and Bluetooth, everything in your home electronics den, from the CDs and DVDs to Blu-ray discs, Dolby sound, the networking standards like Wi-Fi and Ethernet are all standards that relate to interoperability and what we'll be talking about. So we're not talking about consumer electronics today. We're talking about standardization and bioinformatics. And so what kind of standards exist in the world of bioinformatics, and why do we care about these? Well, first, there are terminology standards, and these are really dictionaries that tell you what does it mean when I call something a gene? What does it mean when I call something a protein of a certain nature? There are reporting requirements, minimum sets of information that are going to be required to report a microarray experiment or a certain type of experiment so that other scientists will understand it and will have enough information to reproduce it. Those types of standards, again, not terribly impacted by intellectual property, What is impacted significantly is data exchange formats. So lots of data is coming out of gene sequencing machines, out of spectrography machines, and so forth. How is that data formatted? How is the resulting analytical data formatted in a way that it can be exchanged and used by others? So groups have developed a variety of so-called markup languages that enable data exchange and readability by different groups. And these are interoperability standards, just like the standards that govern exchange of information on the web and elsewhere. So that's what we'll be focusing on. Now, how are all of these standards developed? There are a number of places where standards development occurs. The government is a very logical place. So the Federal Communications Commission, the Food and Drug Administration, state and local bars, accounting organizations. There are governmental and sort of semi-governmental bodies that create standards. Those are often standards that are mandatory. When the Bar Association or the Environmental Protection Agency develops a standard, whether it's for qualification to sit for the bar or for clean air emissions, generally you must comply with those. Companies develop standards themselves. Sometimes they simply develop product configurations that become standards because they're so attractive that everybody wants to use them. Essentially in economic terms, the market adopts them, they become de facto standards. So the Adobe PDF format, the .doc format from Microsoft, JVC's famous VHS tape standard. The younger members of the audience probably don't know what that is, but we used to have these magnetic tapes that you could watch movies off of. Those are all de facto standards developed by individual companies. Then we have a whole range, hundreds of standards development organizations. And in David's talk yesterday morning, we heard about some of these, the ITU, the IETF, and so forth. These are groups, usually nonprofit organizations that are comprised of volunteers from companies in the industry that get together and develop standards for a certain industry, whether it's the internet, telecommunications, or playground equipment. Closely related to those are much less formal and smaller consortia, people that get together for very specific standards projects. So to differentiate between the previous group, the IETF and the IEEE, all of these organizations that start with I typically have dozens, if not hundreds, of different standardization efforts going on simultaneously in many different areas. Consortia will often be devoted to a single standard, such as the DVD storable media format. And then finally, we have academics who get involved in this business, and we'll talk about how that's affected bioinformatics in particular. So, what are the legal issues that come up when we're talking about standard setting? It seems like a very technical activity. Why do lawyers get in and muck this up? Well, there are three principal areas that the law intrudes into this technological area. One is antitrust law, copyright law, and patent law. And I'll make just a few comments about each of these and spend most of my time on the patent section. Okay, so antitrust issues. Every time you have groups of large competitors getting together in the same room, antitrust regulators get a little bit of heart palpitation and get nervous. And so in order to develop these interoperability standards, you do have the manufacturers who are the leaders in the market getting together and deciding what characteristics their technologies will have so that they can talk with each other. And when that happens, there are risks, right? What can they do? Well, they can get together and they can exclude a competitor who thinks that he or she should have been involved in the process. They can exclude that competitor's products, and there has been a significant litigation over just that allegation. There's improper exchange of information, right? These 12 large competitors get together. Well, in addition to talking about standards, they can talk about what the price of DRAM chips is going to be, the price of vitamins and so forth, all sorts of famous price-fixing allegations. And there are lots of opportunities for this to occur both within the standard-setting world and the hallways outside of the conference room where the standards are being set. You have certification misdeeds, right? Again, like exclusion, often standards groups will certify a product that complies with the standard. And if you don't like a particular company's product, well, it's very easy to find faults with it and say, well, it doesn't really comply just because we don't like it. And that really can lead to antitrust problems, and there are all sorts of process abuse questions. There's a famous Supreme Court case involving tubing standards for electrical conduit, the tubing that electrical wires go through in buildings. Question was whether we should approve PVC pipe for these, for this tubing. It used to be aluminum. So the standards body gets together, and lo and behold, the aluminum pipe manufacturers invite about 100 of their friends and family to join the standards body the day before the vote to approve PVC pipe as appropriate conduit for electrical wiring, and of course, it doesn't get approved. And as a result, there's an antitrust claim brought around process abuse in the standards body. So these are all things that standards groups need to be very aware of as they're developing standards. Next, we have copyright issues. So standards are essentially written documents, right? And all written documents, no matter what level of creativity these exhibit, and believe me, if you read these, you would not find these particularly stimulating or creative. Nonetheless, copyright protection does inhere in them when they're created. And they're long. So ASTM, which is one of the largest standards organizations in the world, has a book of standards, and book is a misnomer because it's an 82-volume set, and each volume is about this thick, covering 12,000 standards, and if you bought them all, again, they would fill a pretty good size bookcase, cover everything from medical devices to textiles to plastics, rubber, construction materials, playground equipment, nanotechnology, and fossil fuels. So they are quite comprehensive. And those books are all copyrighted, and everything in them is copyrighted. So there's a big debate within the standards world. Some standards organizations release their standards for free on the internet. The IETF does just that. Others charge and essentially make most of their revenue as publishers. So there is a divide in the standards world over whether or not a standard should be made publicly available or whether it's okay to sell them, particularly when those standards become enacted as part of regulations. Building codes, electrical codes, for example, in cities often incorporate these standards, and there's a doctrine under US law that if there's a law, the public has to know what the law is. So the copyright issues become pretty intense in that context. But the most vehemently litigated issues around technical standards relate to patenting, and there are two primary patent-related issues here. So patent stacking is the first one. This is a phenomenon that arises when you have one standard and lots of different players hold patents that are necessary to implement the standard. So if you have a standard and 12 companies each have a different patent that covers a different aspect of it, in order to practice a standard, you need a license or permission from each of those 12, otherwise you'll be infringing one of their patents. And that's been called many different things. In addition to stacking, you hear it referred to as a patent thicket, and many other similar terms. We'll talk about how that's addressed in a minute. The other issue that patents raise is what has been called patent holdup. Patent holdup can involve just one patent holder, not many. It occurs once a standard is already adopted, right? So take the DVD standard. Manufacturers are going to tool up their factories to make DVDs according to the standard. Movie producers will format their content so that it's in this format. People will buy DVD players that will play these things. After a short period of time, after an important standard is adopted, it's what economists call locked in, right? Huge amounts of capital are invested in